Chapter 18, Bylaws. 56. Content and composition of bylaws. Nature and importance of bylaws. The Constitution and/or bylaws of a society, as explained in 2, contains its own basic rules that relate to itself as an organization, except for what must be included in the corporate charter of an incorporated society. Under the preferred practice for ordinary societies today, the Constitution and the bylaws, once usually separate, are now combined in a single instrument referred to in this book as the bylaws, although in some organizations called the Constitution, or even though only one document, the Constitution and bylaws. A precise statement of the essential characteristics of bylaws in the sense of the combination type instrument and their relation to the other kinds of rules that an organization may have is given in 2, which should be read in connection with this chapter. Because bylaws in this sense are the most important rules which an organization must compose for itself, and because certain considerations must be taken into account that affect their construction as a simplified document rather than a series of separate rules, bylaws are given more detailed treatment below. The content of a society's bylaws has important bearing on the rights and duties of members within the organization, whether present or absent from the assembly, and on the degree to which the general membership is to retain control of, or be relieved of detailed concern with, the society's business. Except as the rules of the society may provide otherwise, its assembly, that is the members attending one of its regular properly called meetings, has full and sole power to act for the entire organization, and does so by majority vote. Any limitation or standing delegation of the Assembly's power with respect to the society as a whole can only be by provision in the bylaws or in the corporate charter or separate constitution, if either of these exists. Committee to draw up bylaws. Appointment of committee. A committee to draw up proposed bylaws is usually appointed at the first organizational meeting where a new society is being formed, as described in 54, or if an existing society wishes to undertake a general revision of its bylaws, a committee to draw up the proposed revision can be appointed at any regular meeting, just as any other special committee. A committee to draw up proposed bylaws should generally be large and should include the most judicious persons available, those who have a special interest in the rules of a society, and those who would otherwise be likely to consume much time in discussing the bylaws when they come before the assembly for adoption. Persons having writing ability of the kind required should also be included, unless a professional parliamentarian is to do the actual drafting of the bylaws. Even if the drafting is to be done by members of the committee, a parliamentarian can often be of great assistance as a consultant. The committee should consult an attorney with reference to the considerations indicated in 5412 if there is any possibility that the society should be incorporated. If it is to be incorporated, the committee works with the attorney to provide him with the necessary information for drafting an appropriate corporate charter, to which the bylaws must conform. The committee should review the draft of the charter before submitting it to the assembly. Initial discussions and factors influencing content of bylaws. The committee normally begins its work with the entire committee present in general discussion of the desired content of the bylaws. Besides reviewing the existing bylaws in the case of a revision, it is well for the committee to study the bylaws of a number of similar organizations, or, if applicable, of other subordinate units within the same state or national society. Before any provisions from any other documents are used as a pattern, however, possible differences between the conditions in the other organization and the one for which the bylaws are being prepared should be carefully analyzed. If the unit for which the bylaws are to be drawn up is subject to a parent organization or superior body, such as a state or national society, or both, or a federation, the bylaws governing at these higher levels should be studied for provisions which are binding upon the subordinate units in a way that must be taken into account. The bylaws of a subordinate unit need to conform to those of a superior body only on clearly requisite points. For example, if the superior body limits the size of its subordinate units to 200 members, the bylaws may not contain a higher limit, but the subordinate unit should not adopt provisions from the other document that have no local application, and the bylaws of the superior body should not require it to do so. In order to give the organization the greatest freedom to act within its object, bylaws should be made no more restrictive nor more detailed in specification than necessary. The description of the basic bylaw articles in 56:16 through 57 provides a brief indication of the framework within which the particular needs of the society should be considered in determining the content of its bylaws. A sample set of bylaws of a type that might be adopted by a small and independent local society is shown in 56:58 through 67. Such a model can only illustrate how a typical document of this kind is put together, however, and the provisions must be varied, additional ones inserted, or inapplicable ones omitted, as appropriate to the individual organization. Drafting of bylaws and appointment of subcommittee or subcommittees. After conferences on the topics described above, the committee should appoint a drafting subcommittee, or several of them for various articles if the bylaws are expected to be long and complex. Another subcommittee may be needed in the latter case to eliminate inconsistencies, make the style uniform, and make sure that, as far as possible, everything relating to a single subject is placed in the same or adjacent articles. The composition of bylaws is somewhat different from ordinary expository writing, and that it places great demand on a tight clarity and precision in word choice, sentence structure, and punctuation. In bylaws, every punctuation mark may have an important effect, and what is omitted may carry as much significance as what is included. Indisputability of meaning and application is a more important consideration than readability, and the latter must be sacrificed when both cannot be achieved. Each sentence should be written so as to be impossible to quote out of context. That is, either its complete meaning should be clear without reference to sentences preceding to or following, or it should be worded so as to compel the reader to refer to adjoining sentences, as by beginning, any member so elected. Exceptions or qualifications to statements should be included as far as possible within the sentence to which they apply, which can often be accomplished by ending sentences with clauses beginning except that, or provided however that. Where such a technique is impractical, a sentence should contain at least an allusion or reference to any exceptions to its own applicability, as in, except as prescribed in Article 6, Section 2 of these bylaws, officers shall. Provisions of a temporary nature or relating to the mechanics of transition from old to revised bylaws should not be included within the bylaws. See 5715 through 17. Regarding the inclusion of provisions of the nature of rules of order within bylaws, see 220 through 21. Critical review by full committee. After the first draft of the bylaws has been completed, it should be given thorough critical examination and discussions by the full committee. The probable long-range effect of each provision should be weighted, and particular care taken to detect and eliminate any remaining inconsistencies or ambiguities. It is much better to take a good deal of time in consideration of bylaws before their adoption than to find an early need for extensive amendment. Presentation of report. After the proposed bylaws are approved by the committee, the report of the committee is presented to the article and is considered seriatim, article by article, and whenever an article consists of more than one section, section by section. The procedure is described in 54:15 through 20 and in 28, except that A, especially in the case of a revision of bylaws, the motion to adopt them may include provisions relating to transition, as explained in 57:15 through 17, and B, a revision of bylaws is adopted by the vote required to amend the existing ones, 56:50 through 56, rather than by a majority vote, as in the case of bylaws that bring a society into being. In presenting the report of the Bylaws Committee to the Assembly, the committee chairman should explain each section and, in the case of a proposed revision of bylaws, make clear what is new about each provision or how it differs from the corresponding provision of the existing bylaws. Content of bylaw articles. Basic bylaw articles. While the number of bylaw articles will be determined by the size and activities of the organization adopting them, and more than those listed below will be needed in some cases, the average society will find it sufficient to include articles on the following numbered headings. The description of appropriate provisions in these articles, while in no sense exhaustive, should prove of help in framing bylaws. Articles are commonly designated with Roman numerals and sections with Arabic numerals. See also sample bylaws 56:58 through 67. For ready reference, it may be helpful to precede lengthy bylaws with a table of contents when they are printed or copied for distribution. Article 1. Name. In unincorporated societies, the full, exact, and properly punctuated name of the society should be given. In incorporated societies or those with separate constitutions, however, the bylaws can omit this article, since the official name of the organization is then stated in the corporate charter or constitution. If the name is in both locations, conflicts may creep in, and it is the name as stated in the superior document that is official. Article 2. Object. In unincorporated societies, the object of the society should be concisely expressed in a single sentence, the various aspects or phrases being written in sequence, set off by semicolons, or in lettered subparagraphs, also set off by semicolons. The statement should be general in its application, since it sets boundaries within which business can be introduced at the society's meetings, a two-thirds vote being required to allow the introduction of a motion that falls outside of the society's object. For the same reason stated above in reference to the society's name, this article can also be omitted from the bylaws in the incorporated societies or in those having a separate constitution. Some societies prefer to set forth the object in a preamble to the bylaws rather than in an article, in which case the preamble precedes Article 1, and the numbering of the remaining articles described below is modified as necessary. This device is especially useful in societies incorporated many years before, whose charter no longer states its object in modern terms or with the specificity now desired. Article 3. Members. Usually the article on members consists of several sections, covering, for example, 1. Classes of members, as active, associate, and the like, with any distinctions between them being set forth, and, as applicable, the rights of each and any limitation on their number, and 2. Qualifications or eligibility for membership, with application and acceptance procedures, including the method of reviewing and voting on applications. Unless the financial obligations of members are especially complicated, a section of this article should also state 3. The required fees and dues, the date or dates when payable, whether annually, semi-annually, quarterly, etc., the time and prescribed procedure for notifying members if they become delinquent in payment, and the date thereafter on which a member will be dropped for non-payment of dues. Before a member in arrears has been finally dropped under such a provision, is voting rights cannot be suspended unless the bylaws so provide. See also 113 Note 3, 32.8, 45.1, 47.39, and 56.61.3. Members cannot be assessed any additional payment aside from their dues unless it is provided for in the bylaws. If the necessary provisions relating to the financial obligations of members of the society are too complex to be included in this article, such provisions can be set out in a separate article immediately following. Some organizations require attendance at a certain portion of the meetings or a specified minimum participation in the society's activities as a requirement for continued membership. This also can be done only by provisions in the bylaws. Sometimes this article also contains provisions for 4 registrations and 5 honorary members. See 4742. In a state or national body or federation, local units or constituent clubs, rather than individuals, may be the members referred to in this article. Article 4. Officers. As stated in 47, every society should specify in this article of its bylaws the officers it requires, including honorary ones, and how they shall be elected or appointed. The officers rank in the order listed, so that the president should be named first, the vice president or first vice president next, unless there is to be a president-elect, see 47:21-22, and so on. Directors should be classed as officers. Normally, all that need be said about the duties of officers, apart from occasional references in other articles under the topics to which that specific duties relate, can be included in the section designating the officers, to the effect that these officers shall perform the duties prescribed by the bylaws and by the parliamentary authority adopted by the society. In cases where the extraordinary duties of officers are numerous, however, a separate article titled Duties of Officers may sometimes follow this article and treat the duties for each office in a separate section. Such a procedure is advantageous in collecting related information in one place, but it results in repetition and may occasion problems of interpretation. Great care must be taken in the writing of the article not to omit any duty, since an implication that the duty is not required could be read into the omission. For this reason, if such an article is to be included, it is well to conclude the section on each office with a clause such as, and such other duties applicable to the office as prescribed by the parliamentary authority adopted by the society. A method of nominating officers, C46, may be prescribed in a section of this article, in the absence of such a provision on any rule adopted by the society. Nominations are made in accordance with established custom, if any, or is otherwise directed by vote of the society at the time of each election. See also 31. If the bylaws provide for a nominating committee and prescribe that the committee shall nominate candidates for each office, the committee is not limited to one candidate for each office. If it is desired to impose such a limitation, the provision should be that the committee shall nominate a candidate for each office. Election by ballot should usually be prescribed in the section pertaining to elections and terms of office, often with additional details of election procedure as discussed in 46. A provision can be included to dispense with the ballot when there is only one candidate for an office, although this deprives members of the privilege of voting for write-in candidates in such a case. If it is desired to elect by mail, by plurality vote, by preferential voting, or by cumulative voting, this must be expressly stated, and necessary details of the procedure should be prescribed. See 45. The length of the terms of office should be prescribed, and unless the terms are to begin at the instant the chair declares each officer elected, the time when they are to begin must be specified. When the bylaws specify the number of years in the term of office, it is understood that the actual term may be more or less than the whole number of calendar years, owing to permissible variation in the dates on which successive elections are scheduled. For example, suppose that the bylaws provide that the annual meeting for the election of officers shall take place in October or November, that their terms of office shall begin at the close of the annual meeting, and that they shall serve for a term of 1 year and until their successors are elected, or simply for a term of 1 year, which is not recommended, see below. If the annual meeting is held on October 20th of 1 year and November 1st of the next, or vice versa, the officers elected at the second meeting take office immediately upon the adjournment of that meeting, and the previous officers remain in office until that time, even though this represents a term of office longer than or shorter than 1 calendar year. For procedures where an election is not completed at the scheduled time, see 46, 44 through 45. To ensure the continued services of officers in the event, for example, of public emergency or of difficulty in obtaining a nominee for an office, the unqualified wording for a term of blank years should be avoided, because at the end of that time there would be no officers if new ones had not been elected. The exact wording that instead ought to be used depends on a further consideration, namely the manner in which the organization wants to make it possible to remove officers before the expiration of their normal term. Careful thought should be given to whether, given the circumstances of the particular organization, it is preferable 1. To permit removal of officers only for cause through disciplinary proceedings that may involve a formal trial, or 2. Instead to permit their removal at the pleasure of the membership by a 2/3 vote, a majority vote in previous notice has been given, or a vote of a majority of the entire membership, any one of which will suffice. See 62:16. To accomplish the first alternative, the bylaws may provide that officers shall hold office for a term of blank years and until their successors are elected. To accomplish the second alternative, the bylaws may provide that officers shall hold office for a term of blank years or until their successors are elected, emphasis added. Because the significant difference in effect between the use of and or is unlikely to be clear to most members, it may be desirable, although it is not essential, to add an explanatory sentence, such as, for the first alternative, officers may be removed from office for cause by disciplinary proceedings as provided in the parliamentary authority. For the second alternative, officers may be removed from office at the pleasure of the membership as provided in the parliamentary authority. Since a reasonable rotation in office is desirable in almost all organizations, a section of this article may well provide that no person shall be eligible to serve blank consecutive terms, specifying the number, in the same office. For purposes of determining eligibility to continue in office under such provision, an officer who has served more than half a term is considered to have served a full term in that office. The method of filling vacancies may also be provided, consider 47, 57 through 58. Unless the bylaws clearly provide otherwise, notice of filling a vacancy in office must always be given to the members of the body that will elect the person to fill it. If the bylaws are silent as to the method of filling a vacancy in the specific case of the presidency, the vice president or first vice president automatically becomes president for the remainder of the term, and the vacancy to be filled arises in the vice presidency or lowest ranking vice presidency. If another method of filling a vacancy in the presidency is desired, it must be prescribed and specified as applying to the office of president in particular. Article 5, Meetings. The first section of the article on meetings should fix the day on which regular meetings of the society are to be held, as by specifying, for example, the first Friday of each month. If the words "unless otherwise ordered by the society or executive board" are added, the date can be changed in an unusual circumstance, but only for that single meeting on that particular occasion, and not for a period of time including several meetings. To change the general rule fixing the time for meetings would require amendment of the bylaws. The hour and place at which meetings are to be held should not be specified in the bylaws, but should be established by a standing rule, 2, adopted by the society, or, if it is empowered to do so, by the executive board. Some organizations prefer to schedule a meeting by resolution. If so, the bylaw should provide for the number of days' notice required before regular meetings, since under a practice, members cannot determine the meeting dates by consulting the bylaws. Unless otherwise provided in the bylaws, the number of days is computed by counting all calendar days, including holidays and weekend, excluding the day of the meeting, but including the day the notice is sent. In a separate section, it should be provided that the regular meeting, specifying which one, as on the last Tuesday in May, shall be known as the annual meeting. As explained in 9, this meeting is conducted in the same way as any regular meeting, except that officers are elected and annual reports are received from officers and standing committees. A section authorizing the calling of special meetings should state by whom such members can be called, such as the president, the board, or a specified number of members nearly equal to a quorum, and the number of days' notice required. It may be well to provide that no business shall be transacted except that mentioned in the call, that is, the notice, of the special meeting, although this rule would apply even if not expressly stated, see 9:15. If the bylaws do not authorize the callings of special meetings, such meetings are not permitted, except when authorized by the Assembly itself as part of formal disciplinary procedures for the purposes of conducting a trial and determining a punishment. See 6321, Note 9. The quorum for all meetings should be established in a section of this article, see 40. In a state or national bodies where one session, usually called a convention, is held annually, biennially, or at least less frequent intervals, the article on meetings is titled Conventions. While much that is stated above would be generally applicable to such an article, considerable adaptation is needed as described in 58:6 through 10. Article 6, Executive Board or Board of Directors. As explained in 49:3 through 7, all but the small societies usually find it advisable to establish a board whose members are the officers of the society, such a body being entrusted with administrative authority and responsibility to a degree that varies with the organization. If there is to be such a board, sections of this article should specify the board's composition, delineate the powers of the board, and set forth any special rules by which the board is to conduct its business, such as when and how often it is to meet, and its quorum, and the like. In most societies, this body is called the executive board, unless there is to be a smaller body within it to act for the board between its meetings, in which case the full board is usually designated the board of directors, and the smaller body is called the executive committee, see 49:13. The executive committee is then established in a separate article following the one on the complete board, with similar provisions. The bylaws may provide for how the presiding officer and the secretary of the board and those of the executive committee are to be determined. In the absence of such provisions in the bylaws, however, the president and the secretary of the society also serve in the same capacities within these bodies. Organizations may sometimes give varied names to their full boards, such as Board of Managers, Board of Trustees, Board of Governors, Administrative Council, etc. In such cases, the nature of the particular body, as one of the types described above, can be determined from the bylaw article that establishes it. A board may never alter a decision of the Society's assembly, and an executive committee may never alter a decision of either the assembly or the board, even by a motion to rescind or amend something previously adopted, or by adoption of a proposal which has been rejected, unless expressly authorized by the superior body or by the bylaws. See 49.7. Thus, for example, if it is desired that the assembly adopt an annual budget, but that the board be empowered to alter it to deal with contingencies that may develop, the bylaws, or the budget resolution, must specifically confer this power on the board. Article 6, Section 2 of the sample bylaws, 5664, shows an appropriate wording for determining the board's powers so that the board's authority will be limited to the power to supervise and to determine the details of implementation of the decisions of the Society's assembly, and, in a manner not inconsistent with such decisions, to attend to any business of the Society that cannot wait until the next meeting. If the organization desires to leave the entire administrative authority of the Society to the board between the Society's meetings, as may occur, for example, in organizations that meet infrequently or whose main purpose is other than to transact business, the same section might read: The Executive Board, or Board of Directors, or whatever else, shall have full power and authority over the affairs of the Society, except specifying classes of business over which the Assembly of the Society is to retain sole authority. Article 7. Committees. The article on committees should provide for the establishment of each of the standing committees, 50, that is known will be required. A separate section devoted to each of these committees should give its name, composition, manner of selection, and duties. If this article names certain standing committees, no other standing committees can be appointed without amending the bylaws, unless a provision is included, usually in a separate section of the article as described below, permitting the establishment of such other standing committees as are deemed necessary to carry on the work of the Society. In any event, if a standing committee is to have standing authority to act for the Society without specific instructions, if business of a certain class is to be automatically referred to it, or if some other rule of parliamentary procedure is affected by the committee's assigned function, such procedure must be prescribed in a provision of the bylaws or in a special rule of order establishing the committee by name. The number and nature of the standing committees that may be named in individual sections on this article will depend on the size and object of the organization. The standing committees most frequently established by local societies are few in number. They may include a committee on membership, a program committee, and sometimes a finance committee. A section relating to the nominating committee, when included, is usually located not in this article, but in the article on officers, where nomination and election procedures are usually prescribed. In national or state bodies, more committees may be needed, but local units should not try to establish a committee to correspond to each one in the superior body, and the superior body generally should not require them to do so. Appointment of special committees is usually provided for in a separate section that may also, as indicated above, provide for the appointment of additional standing committees. When this section empowers the president to appoint such special committees or additional standing committees as the Society or the board shall direct, he is not thereby authorized to appoint other committees on his own initiative. If the president is to appoint committees and it is desired that he have standing authority to appoint non-assembly members to positions on the committees without submitting these persons' names to the assembly for approval, this section should contain a provision to that effect. See 1315, 5012, and 5013D. This section may also provide that certain officers, for example the president, shall be ex officio a member of all committees except the nominating committee. In that case, the president has the right but not the duty of participating in the work of the committees. See also 49.8 and 5016. Without such provision, he has no vote within the committees, nor can he attend their meetings except as invited by a particular committee. The nominating committee should always be expressly excluded in a provision making the president an ex officio member of committees. It may also be advisable to exclude all disciplinary committees, such as trial and investigation committees, both from a provision making the president an ex officio members of committees and from a provision authorizing the president to appoint committees. If no article on committees is included in the bylaws, standing and special committees are established as directed by the Society. See 13 and 50. Article 8, Parliamentary Authority. The parliamentary authority, through the adoption of which a society establishes its rules of order, should be prescribed in a one-sentence article reading, "The rules contained in the current edition of," and then specifying a standard manual of parliamentary procedure, such as this book, shall govern the society in all cases to which they are applicable and in which they are not inconsistent with these bylaws and any special rules of order the society may adopt. Note: where a particular type of organization is subject to local, state, or national law containing provisions relating to procedure, as for certain procedures in the labor organization, in condominium associations, or in an incorporated association, it may be desirable to add at this point a phrase such as, "and any statutes applicable to this organization that do not authorize the provisions of these bylaws to take precedence." However, such statuses those that do not authorize bylaws to take precedence, supersede all rules of the organization which conflict with them, even if no mention is made of it in the bylaws. Back to reading. Societies can adopt social rules of order as they are needed to supplement the parliamentary authority, as explained in 2. It should be noted that the bylaw language recommended above does not authorize the adoption of a special rule of order that would supersede a rule that the parliamentary authority states can be altered only by provision in the bylaws. When a particular work is adopted as the parliamentary authority, what any other book may say on any point is of no authority if in conflict with the adopted work. In other cases, it may be persuasive, but it is not binding upon the society. Article 9. Amendment of bylaws. The bylaws should always prescribe the procedure for their amendment, and such provision should always require at least that advance notice be given in a specified manner, and that the amendment be approved by a 2/3 vote. If the bylaws contain no provision for their amendment, they can be amended by a 2/3 vote if previous notice, in the sense defined in 1044, has been given, or they can be amended by the vote of a majority of the entire membership. In making a requirement that notice be given by submitting the amendment at a meeting in advance of the one at which it is to be considered, the provision should always specify submission at the previous meeting and not a previous meeting, since the latter would permit indefinite delay and would defeat the object of giving notice, namely to alert the members to the proposed amendment so that all those interested can arrange to be present at its consideration. The requirement of notice restricts amendment of the proposed bylaw amendment to changes within the scope of the notice, as explained in 5710-13. See also 35-6. The manner prescribed for giving notice should suit the needs of the particular assembly. For some, oral notice is sufficient. Others may require written notice. Some may require only a general statement of the purport of the amendment. Others may require that the exact wording of the amendment be given. If the bylaws require only previous notice of an amendment without limitation of the period within which it must be acted upon, and a committee is appointed to revise the bylaws and report at a specified meeting, the appointing action is all the notice required, and the amendments can be immediately acted upon at the time the committee reports. But if it is required that the amendment itself, or notice of such amendment, be submitted at the previous regular meeting, the revision cannot be taken up until the meeting following this meeting at which the committee submitted its report. And societies having very frequent regular meetings primarily for presentation of a program, and also monthly or quarterly business meetings, 9.1, it is well to permit action on amendments to the bylaws only at a quarterly or annual meeting of their adjournments. Where assemblies meet regularly once a year, instead of requiring amendments to be submitted at the previous annual meeting, the bylaws should provide for both notice and copies of the proposed amendment to be sent to the member, delegates, or constituent societies a specified minimum number of days in advance. If there is constitution separate from the bylaws, the requirement for amendment of the constitution should be made more difficult than that for amendment of the bylaws. Otherwise, there would be no purpose in having separate documents. In either case, however, the necessary vote should be at least 2/3. In prescribing the vote necessary for the adoption of an amendment, the expression "a vote of 2/3 of the members" should never be used in ordinary societies, especially in large organizations. In such societies, 2/3 of the entire membership would rarely, if ever, be present at a meeting. It is more reasonable to require a 2/3 vote. See 44-3-6. The wording of this article should avoid redundant phraseology such as amend, alter, add to, or repeal, or alter or amend or in any way change. The word amend covers any change, whether a word or a paragraph is to be added, struck out, or replaced, or whether a new set of articles is to be substituted for the old one. Efforts to determine the meaning of such expressions as 2/3 vote should also be avoided in the wording of this article, since these definitions are found in the parliamentary authority. Additional bylaw articles. Some societies may have cause to include additional bylaw articles, such as those mentioned above, bearing on the subjects of finance, duties of officers, and an executive committee of the board of directors. In a national organization, an article providing for constituent societies or units at regional, state, or local levels, and establishing their relationship within the organizational structure, may be required. In associations divided into departments, the article establishing them, titled departments, follows the article establishing committees. In professional and some other societies, there may be an article on disciplinary procedure, and such an article can be simple or very elaborate. Most such provisions, however, are generally unnecessary in ordinary societies, at least at the local level. See 61-63. Sample bylaws. Regarding the applicability of the following model, see 56.9. Titles of sections are optional, but they may be felt to be desirable, particularly if the bylaws become elaborate, as may be the case, for example, in a complex national organization. Bylaws of the blank society of blank. Article 1, name. The name of the society shall be blank. Article 2, object. The object of the society shall be to blank, and to blank. Article 3, members. Section 1, maximum membership. The membership of this society shall be limited to 200 members. Section 2, membership eligibility and admission procedure. Any adult resident of blank shall be eligible for membership, provided that such resident shall be proposed by one member and seconded by another member of the society. A proposal for membership signed by the two endorsers shall be sent to the recording secretary, who shall report it, together with the names of the sponsors, at the next regular meeting of the society. Voting upon the admission shall take place at the next regular meeting thereafter. A 2/3 vote shall elect to membership. A person so elected shall be declared a member of the society upon payment of the initiation fee and the annual dues for the first year. Section 3. Initiation fees and dues. The initiation fee shall be blank dollars, the annual dues shall be blank dollars, payable in advance on or before blank of each year. The treasurer shall notify members blank months in arrears, and those whose dues are not paid within blank thereafter shall be automatically dropped from membership in the society. Section 4. Resignation from membership. Any member desiring to resign from the society shall submit his resignation in writing to the recording secretary, who shall present it to the executive board for action. No member's registration shall be accepted until his dues are paid. Section 5. Honorary life membership. Upon the signed recommendation of one member, seconded by another member, and by a 3/4 vote by ballot at the annual meeting, honorary life membership may be conferred upon an adult resident of blank who shall have rendered notable service to the society. An honorary member shall have none of the obligations of membership in the society, but shall be entitled to all of the privileges, except those of making motions, of voting, and of holding office. Article 6. Officers. Section 1. Officers and duties. The officers of the society shall be a president, a first vice president, a second vice president, a recording secretary, a corresponding secretary, a treasurer, and 4 directors. These officers shall perform the duties prescribed by these bylaws and by the parliamentary authority adopted by the society. Section 2. Nomination procedure and time of elections. At the regular meeting held on the second Tuesday in February, a nominating committee of 5 members shall be elected by the society. It shall be the duty of this committee to nominate candidates for the offices to be filled at the annual meeting in April. The nominating committee shall report at the regular meeting in March. Before the election at the annual meeting in April, additional nominations from the floor shall be permitted. Section 3. Ballot election, term of office, and removal from office. The officers shall be elected by ballot to serve for 1 year or until their successors are elected, and their term of office shall begin at the close of the annual meeting at which they are elected. Officers may be removed from office at the pleasure of the membership as provided in the parliamentary authority. Section 4. Office holding limitations. No member shall hold more than 1 office at a time, and no member shall be eligible to serve 3 consecutive terms in the same office. Article 5. Meetings. Section 1. Regular meetings. The regular meetings of the society shall be held on the second Tuesday of each month from September to May inclusive, unless otherwise ordered by the society. Section 2. Annual meetings. The regular meeting on the second Tuesday in April shall be known as the annual meeting and shall be for the purpose of electing officers, receiving reports of officers and committees, and for any other business that may arise. Section 3. Special meetings. Special meetings may be called by the President or by the Executive Board and shall be called upon the written request of 10 members of the society. The purpose of the writing of the meeting shall be stated in the call, which shall be sent to all members at least 3 days before the meeting. Section 4. Quorum. 15 members of the society shall constitute a quorum. Article 6. The Executive Board. Section 1. Board composition. The officers of the society, including the director, shall constitute the Executive Board. Section 2. Board's duties and powers. The Executive Board shall have general supervision of the affairs of the society between its business meetings, fix the hour and place of meetings, make recommendations to the society, and perform such other duties as are specified in these bylaws. Section 3. Board meetings. Unless otherwise specified by the Board, regular meetings of the Executive Board shall be held on the first Tuesday of each month from September to June, inclusive. Special meetings of the Board may be called by the President, shall be called upon the written request of 3 members of the Board. Article 7. Committees. Section 1. Finance Committee. A finance committee composed of the treasurer and 4 other members shall be appointed by the President promptly after each annual meeting. It shall be the duty of this committee to prepare a budget for the fiscal year beginning the first day of April and to submit it to the society at its regular meeting in March. The Finance Committee may from time to time submit amendments to the budget for the current fiscal year, which may be adopted by a majority vote. Section 2. Program Committee. A program committee of 5 members shall be appointed by the President promptly after the annual meeting, whose duty it shall be to plan the annual program of the society. This committee's report shall be submitted to the society for its approval at its regular meeting in September. Section 3. Auditing Committee. An auditing committee of 3 members shall be appointed by the President at the Society's March meeting, whose duty it shall be to audit the Treasurer's accounts at the close of the fiscal year and to report at the annual meeting. Section 4. Other committees and the President's ex officio committee membership. Such other committees standing as special may be established by the Society as it shall from time to time deem necessary to carry on its work. Their members shall be appointed by the President unless this rule is suspended by a 2/3 vote before their appointment. The President shall be ex officio a member of all committees except the nominating committee and any disciplinary committees. Article 8. Parliamentary Authority. The rules contained in the current edition of Robert's Rules of Order newly revised shall govern the society in all cases to which they are applicable and in which they are not inconsistent with these bylaws, and any special rules of order the society may adopt. Article 9. Amendment to Bylaws. These bylaws may be amended at any regular meeting of the society by a 2/3 vote, provided that the amendment has been submitted in writing at the previous regular meeting. Some principles of interpretation. In preparing bylaws and interpreting them, the following principles of interpretation, which have equal application to other rules and documents adopted by an organization, may be of assistance. 1. Each society decides for itself the meaning of its bylaws. When the meaning is clear, however, the society, even by unanimous vote, cannot change that meaning except by amending its bylaws. An ambiguity must exist before there is any occasion for interpretation. If a bylaw is ambiguous, it must be interpreted, if possible, in harmony with the other bylaws. The interpretation should be in accordance with the intention of the society at the time the bylaw was adopted, as far as this can be determined. Again, intent plays no role unless the meaning is unclear or uncertain, but where an ambiguity exists, a majority vote is all that is required to decide the question. The ambiguous or doubtful expression should be amended as soon as practicable. 2. When a provision of the bylaws is susceptible to two meanings, one of which conflicts with or renders absurd another bylaw provision, and the other does not, the latter must be taken as the true meaning. For example, assume the bylaws define the officers as a president, a vice president, a secretary, a treasurer, and 5 other members, all of whom shall serve as members of the board. Assume also that elsewhere the bylaws speak of directors being board members. A suggestion that the directors are not officers and are additional members of the board would create a conflict within the bylaws and cannot be taken as the true meaning. The other members are the same as the directors. 3. A general statement or rule is always of less authority than a specific statement or rule and yields to it. It is not practical to state a rule in its full detail every time it is referred to. General statements of rules are seldom strictly correct in every possible application. The specific statement of the rule that gives the details applying to the particular case must always be examined. For instance, in the sample bylaws, Article 3, Section 2, 5661, it is provided that any adult resident shall by 2/3 vote be elected to membership. This is a general statement which yields the proviso stated in Section 1 of the same article that restricts membership to 200. Thus, the society is not empowered to elect a 201st member by a 2/3 vote. No one has a right to quote a general statement as authority against a specific statement. 4. If the bylaws authorize certain things specifically, other things of the same class are thereby prohibited. There is a presumption that nothing has been placed in the bylaws without some reason for it. There can be no valid reason for authorizing certain things to be done that can clearly be done without the authorization of the bylaws, unless the intent is to specify the things of the same class that may be done, all others being prohibited. Thus, where Article 4, Section 1 of the sample bylaws, 5662, lists certain officers, the election of other officers not named, such as a sergeant at arms, is prohibited. 5. A provision granting certain privileges carries with it a right to a part of the privileges, but prohibits a greater privilege. The sample bylaws in Article 6, Section 2, 5664, propose that the Executive Board may fix the hour and place of the meetings of the Society. The Board may therefore change the time or the place or both of a Society's meeting, but it may not change the day for which the meeting is scheduled. 6. A prohibition or limitation prohibits everything greater than what is prohibited, or that goes beyond the limitation, but it permits what is less than the limitation, and also permits things of the same class that are not mentioned in the prohibition or limitation, and that are not evidently improper. The sample bylaws Article 4, Section 4, 5662, limits a member to holding one office at a time. This limitation carries with it, of course, the prohibition of holding more than 2 or 3 offices as well. The next clause in Article 4, Section 4, prohibits officers from serving 3 consecutive terms in the same office. Hence, an officer cannot serve 4 consecutive terms, but may serve 2 consecutive terms. Article 9 of the sample bylaws, 5667, limits amendments to the bylaws to those of which notice has been given, and which are adopted by a 2/3 vote. Thus, the change of a single word is prohibited unless these conditions are met, and a revision of the entire bylaws requires that the same steps be taken. 7. The imposition of a definite penalty for a particular action prohibits the increase or diminution of the penalty. If the bylaws state that a member shall be dropped from membership on a board if he misses 3 consecutive regular meetings of the board, he cannot be retained by vote of the board, nor can more severe penalties be imposed, such as a fine in addition. If, for example, it is desired to allow the board to diminish or waive the penalty or increase it, the bylaw must not make it definite or must specifically provide for diminution, waiver, or enlargement. 8. In cases where the bylaws use a general term and also two or more specific terms that are wholly included under the general one, a rule in which only the general term is used applies to all the specific terms. Where the bylaws provide in the basic enumeration of the classes of membership that members may be active, associate, or honorary, the general term member is used to apply to all 3 classes of members. But if, in the article on members, it is stated that members may be either active or associate members, or if the article simply describes members without classification, as in the sample bylaws, Article 3, 5661, the term member applies only to those classes or that class of members, even if honorary members are provided for elsewhere, in which case honorary membership is not real membership. Similarly, if the bylaws provide for elected officers and appointed officers, the word officers, or the expression all officers, used elsewhere in establishing the term during which office shall be held, applies to both the elected and the appointed officers.